Okay, so why don't you, when you start, why don't you leave that slide up? So don't advance it right away. Just leave that up, okay?
When do you want me to advance it? Whenever I actually kick into it?
Once I put both of you together, if you want to advance it at that point, you can. You know, when we go to this view,
Yes.
after that, you can change it,
All right.
okay? Yeah. So, here we go. We're gonna do take 2. Stand by, and we are recording. Wait till you come up.
You know, I listened to the prosecutor's opening statement to y'all this morning, and I couldn't help but think there is a whole nother story that you all haven't heard. What they have done for all practical purposes is they have told you everything that they believe that Mr. Stapleton did wrong, and they have omitted everything that he did right that night. They've omitted all the mistakes that the officers made that night. They omitted all the mistakes that were made in caring for the blood sample that night. Those problems and that evidence are crucial to the case here. They're crucial to whether or not they can prove the charges against Mr. Stapleton beyond a reasonable doubt. They're crucial to the decisions that you have to make. And I want you all to know that whenever we evaluate the evidence in this case, I actually believe it's a very straightforward, simple set of facts. And that if they would honestly acknowledge the mistakes that they made, the lapses in their evidence, the things that are missing, we'd all say, hey, there's really no real question as to whether or not they can prove these charges beyond a reasonable doubt. They cannot. They can't honestly acknowledge those problems because they are in fact fatal to their case. That's what I believe the evidence will show us again and again in this case. What happened in this case is truly a rush to judgment. It's one in which the officers, you're going to see time and time again on the roadside, they made statements, they locked themselves into certain statements, they made statements that were not supported by the evidence, and then they tried to just bolster them. It's sort of a case in which you tell a lie and then you have to tell a bigger lie in order to try to dig yourself out of it. The only problem that the state has in this case is that there are documents and there are videos in this case that directly contradict those statements and those fabrications, those exaggerations that the officers make in this case. There's really no question about what it is that actually happened. You're going to see it all on the video. You're going to see the way that Mr. Stapleton drove. You're going to see the way that Mr. Stapleton and hear the way that Mr. Stapleton talked. You're going to see that the way that he walks, the way that he balances on one foot, the way that he does the walk and turn test. All of those pieces of evidence are going to be here for you to see. You're going to see the way that they cared for the blood sample. You're going to see the way that they did not put a proper seal on it, the way that they did not properly invert the sample or shake it and mix it up after it was drawn from Mr. Stapleton. And most importantly, you're going to see the way that they did not refrigerate the blood sample for over 22 days prior to the testing of it. These are all crucial errors that exist in this case. They're all things that the state will not acknowledge to you. They did not acknowledge them even this morning whenever they got up in front of you. They won't ever tell you that we made those mistakes. They're going to do exactly what the officer did in this case. They're going to ignore the realities of the facts of this case. They're going to exaggerate things, and they're going to make up facts and conclusions because their evidence doesn't substantiate it. They're going to say, although our protocol tells us that we're supposed to refrigerate a blood sample as soon after it's drawn as possible, just ignore a 22-day gap, more than 22 days, where the blood sample was not properly refrigerated. Ignore the fact that the blood sample wasn't properly sealed. Ignore the fact that the phlebotomist shook it up in a way that he's not supposed to after the blood was drawn from Mr. Stapleton. Ignore the fact that the officer did not properly administer the walk and turn test. Ignore the fact that the officer said that he saw clues on the one-leg stand that you are going to see Mr. Stapleton stand on his foot for over 30 seconds with absolutely no trouble whatsoever. The officer has to make up facts in order to try to prove that Mr. Stapleton was under the influence that night that simply are not corroborated by the video in this case. And you're going to see that problem over and over again as we go through the evidence here. This is the officer. These are little snippets from the video in this case that you're going to see. This is where the officer is laughing, talking about Mr. Stapleton running off the road and throwing glass up on his windshield and that sort of stuff. And you're actually going to see Mr. Stapleton driving. You're actually going to see the officer's windshield. You're going to see that there is no grass that pops up. And you're going to see, hey, even stuff like, for example, the officer concluded that Mr. Stapleton had to have something that was causing his eyes to be constricted. The blood test showed no evidence of any substance whatsoever, Mr. Stapleton, that would have caused his eyes to be constricted. The best evidence of whether or not Mr. Stapleton was under the influence of something that would have caused a reaction like that is in fact the blood test, and it simply is not there in this case. The video in this case doesn't support the officer's exaggeration of Mr. Stapleton's driving, of him running off the road and kicking up grass onto his windshield. It's just not there in this case. The officer says that, hey, I believe that you're under the influence of Adderall. He was completely wrong about this conclusion. On the walk and turn test, for example, he saw 4 of 8 clues. What you need to know about that test and those 4 of 8 clues, for example, that the officer says he observed, the officer sets up Mr. Stapleton in the wrong position. So he sets him up for failure. As a result of that, Mr. Stapleton takes off on the wrong foot. He then tries to make the turn that the officer demonstrated for him. The problem is that in order to make the turn as demonstrated by the officer, he has to take an incorrect number of steps, because if you don't start off on the right foot, you have to take an additional step in order to get to your left foot being planted and make a series of steps around your right foot. That's 2 clues that the officer observed right there, was that he took the incorrect number of steps and he made an incorrect turn. The officer set him up to fail, and he will not acknowledge that problem in making the determination as to whether or not Mr. Stapleton was under the influence. The officer, time and time again, ignores those realities, exaggerates, and makes up facts to support it. But there's a lot of reasons as well just to believe that, based upon what it is that we see Mr. Stapleton, setting aside the mistakes that Officer White made in this case, to believe that Mr. Stapleton, just based on his own performance, is not under the influence. Setting aside the mistakes that the officer makes, we have affirmative evidence that shows us that Mr. Stapleton is not impaired in this case. He walks normally, he talks normally, and he performs exceptionally well on very difficult set of field sobriety tests in this case. We cannot ignore that affirmative evidence that shows us that Mr. Stapleton is in fact not impaired by alcohol in any way, shape, or form in this case. The one-leg stand test, the officer says he saw 2 clues that would support an arrest decision based upon his own training. What I want you to know about that is that you're going to see a video, and ladies and gentlemen, there just simply is not evidence of impairment on the one-leg stand test. The clues that the officer says that he observed are not present in any way, shape, or form on that video. And it is absolutely critical to the evaluation of the officer's credibility, but also just to whether or not we can determine, based on the evidence that we actually have, the video that we can all see, hear, and observe for ourselves, in determining whether or not Mr. Stapleton was under the influence. And there is no evidence there that will corroborate it. There's 2 different types of DUI charges. And normally at the beginning, I'd like to go ahead and talk to you about that because it's critical. Everything that I've talked to you about so far in terms of the evidence on the side of the road goes to count 1, which is the DUI less safe charge that Mr. Stapleton faces. All of the evidence in terms of his driving, his manner of speech, his manner of walking, his manner of talking, his manner of performing the field sobriety tests, all goes to whether or not Mr. Stapleton was in fact impaired, a less safe driver on this night, in making that determination for us. That's the evidence that you have to rely upon. The evidence in count 2 relates to the blood test in this case. And I believe if we were to truly be honest, if the state were to really tell you, hey, this is what we're really here about, they would say, in fact, that count 2 is the real reason that we're here, because you just can't look at the video in this case and really believe that the evidence supports that Mr. Stapleton was under the influence. Once you see him, once you hear him, once you see the field sobrieties, that's a very difficult conclusion for reasonable people to reach just based on what it is that's here. If we're being straightforward, being candid about that, that's probably the truth of the matter. So let's talk about why it is that we're really here. And I believe the blood test is at the heart of that. First, there's 3 problems as it relates to the blood test. First problem is that the blood vials were not properly sealed. And I'll show you the photo that you're going to see in just a moment whenever we actually get to the evidence in the case. The second is that the phlebotomist in this case, under the GBI protocols, and these are all rules that are required under the GBI protocol. These are all rules of the Georgia Bureau of Investigations that were violated in the performance of the blood test on Mr. Stapleton's samples in this actual case. These are all problems that are here and all problems that the state, as we just heard, will not acknowledge that these problems are there and they actually affect the reliability of it, despite the fact that that's what the GBI and their own rules and regulations require. These are all rules that were violated in Mr. Stapleton's case. First, the blood vials are not properly sealed. You'll see a picture of it. It's clear as day whenever it's in the Ziploc bag that's transported to the Georgia Bureau of Investigation's toxicology lab, where the vials are not properly sealed. Second, you're going to see a video of the actual blood vials after they've drawn the blood from Mr. Stapleton's arm. You're going to see a video of how it is that the phlebotomist goes to invert the samples. And they're actually required to flip them over a series of times. But they don't do it in this case. They start shaking it. And there's actually a rule that's in the GBI's protocol for the administration of the blood draw and how it is that you're supposed to mix the preservatives that are in there, how it is that you're supposed to mix them properly to maintain the blood sample itself. And you're going to see a video of the phlebotomist actually shaking that blood vial in a way that directly contradicts what the rule actually says, which is do not shake it. The third problem, which I believe is tantamount to any problem that already exists here, as if we weren't troubled enough by there not being a seal on the blood vial, as if we weren't troubled enough by the improper inversions of the blood vial. We've got 22 days in which the blood samples are not refrigerated. The GBI rule requires that blood samples be refrigerated as soon as possible after the draw. And there's absolutely no explanation for it whatsoever. And it absolutely compromises the reliability and validity of those samples, as you'll hear from the evidence in this case. So this is what the rule actually says, where it requires a proper closure, a proper seal of the blood vial. That's going to be admitted into evidence. You will see that. We'll go over that in depth at trial. And this is the actual blood vial itself, where you see that there is no tape, no closure of the blood vial as required by that rule. The second violation that we talked about of the rules of the GBI, do not shake vigorously, and you are absolutely going to see a video that shows that blood vial being shaken multiple times by the phlebotomist, in no way being careful, in no way trying to comply with their own rules as it relates to the care for that sample. And then the third violation is that the sample should be refrigerated as soon as possible. And 22 days after the fact just simply does not even come close to complying with that requirement in order to make sure that the blood vial and the validity of those tests can be relied upon, that we don't have a problem with production of alcohol within that blood vial as a result of the samples not being properly refrigerated. You'll hear from our experts at length in the trial of the case that will talk to you about why it is that's a real problem and one that we cannot rely upon a test that's performed upon a sample that hasn't been properly refrigerated for that amount of time. This is the chain of custody that's actually provided by the Sheriff's Department and by the GBI that shows you when in fact the blood vial was not properly refrigerated. They ignored their own rule, and now the state in turn is asking you to ignore that rule. They're throwing it back on you to say, save us in this case. And that's not what we're here to do. We're not here to excuse violations of their rules. We're not here to excuse violations of their safety protocol. We're here to determine, based upon the evidence in this case, can you show us that in fact that rule doesn't matter, despite the fact that the GBI has adopted that, despite the fact that that is part of their protocols for the administration of that. And ladies and gentlemen, there will be no evidence of that. So what we're asking you to do is return a verdict of not guilty as to count 1, DUI less safe, return a verdict of not guilty as to DUI per se in count 2. On count 3, with a failure to maintain lane, you're going to have to decide that. It's a very close call based upon the video. You will see Mr. Stapleton hit the white line, the fog line in this case. But whether or not that constitutes failure to maintain lane is going to be up to y'all, and that will be a tough call. But as to counts 1 and count 2, they're the real reasons why we're here. We're asking that you return a verdict of not guilty. Thank you. So what I was trying to do is to give you as not a detailed of an opening statement, but just to sort of give you a cursory view of what it is that most of my opening statements typically look like. Obviously, we're in a different setting by virtue of me doing this in my office. It's a little bit unusual for sure. But I thought back to whenever I was trying my first blood case in particular and a first breath test case. And I remember how unnerving it was to try to get ready for those opening statements, to try to get ready for my closing arguments, and to try to just get ready for the trial in general without really having a good idea for a template that I could use for going through an opening statement. So I hope that whenever you see the video that it will give you some insights as to things that you could do, but also to realize that this does not need to be overwhelming for you. You can pick out a pretty clear theme, pretty clear theory of defense, and you can really go through this in a way that is not overwhelming for you. So I thought that maybe if you saw sort of a brief demonstration of it, it might help you in streamlining that process and to know that the fear, the anxiety that we all indefinitely have about those types of cases for sure, whenever there's a test that's being admitted into evidence, that you can do this thing. If I can do it, anyone can do it, is what I tell people all the time. So I didn't introduce myself at the beginning just because I wanted to kind of go into it, and I think that it's more engaging with you if you go ahead and see the demonstration itself without doing that. My name is Ben Sessions. I'm primarily a DUI defense lawyer in Atlanta, Georgia. I'm board certified in DUI defense. I've been doing this for about 16 years. So I want to go through with you now what I believe to be the basics of the opening statement. First, I didn't go into a ton of factual recitation in that case, the demo that I just did, but I do believe that you should be extremely fact intensive in your opening statements. The more fact intensive that you are, it goes directly to what I believe to be probably one of the most important things in your opening statement, which is you're trying to become the most credible lawyer in the courtroom. That's part of the reason why I love to do that totality of the circumstances versus totality of the negative circumstances that the state tries to do, because it looks like you're wearing the white hat, that you're telling the whole story. You're giving all the facts in the way that the prosecution typically does not. So go into a very detailed factual recitation. And you can even go through the field sobriety test and say there are 3 standardized field sobriety tests in the typical battery of field sobrieties. These are what the number of clues are. And usually what I'll do is I'll really go into real detail about the horizontal gaze nystagmus test. I know there's some people who are watching the video where it's not admissible in the trial of the case. In this particular case, it was admitted. So what I usually do is whenever I'm talking about the horizontal gaze nystagmus test, I overwhelm jurors with information about it. I talk to them in exactly the same terms that the officer's going to. I go ahead and use the analogy of the windshield wipers running across a dry windshield. That's what we always hear from officers about what the jerking of the eyes looks like during the administration of that test. And it's something that for jurors, they're sitting there listening to it like, geez, this guy's giving me so much information and he's telling me at the end of the day that it really doesn't matter. Once the officer gets up there and starts talking about the same exact things, I see jurors' eyes just glaze over like, come on, we've already heard all about this in this guy's opening statement. Why do we need to hear it again? And what it does is it has the tendency to just take the sting out of it. Just by virtue of talking about that evidence so much, jurors then look at it and say, we've already heard this, we know it's not that significant, and oh yeah, he already told us we don't have a video of the actual jerking of the eyes that we have in this case. So that's what I try to do in terms of being as fact intensive as I can in the opening statement. It really builds credibility if you have such a command of the facts in a way that the prosecutors don't. And beyond just the actual facts itself, the evidence, the actual field sobriety tests, and knowing what those tests are is what you're going to get throughout, day in, day out throughout this seminar. Having a real command of the field sobrieties and the limitation of field sobriety tests is a huge benefit for you in terms of how it is that jurors view your credibility to them. We're arguing the case in a very objective way, and I am completely clear about this. I am borderline closing argument in the vast majority of my opening statements that are really good. Whenever I'm giving a opening statement, not a closing argument, that is really good, most prosecutors are very close to objecting to it, and that's okay. I'm willing to push that envelope because, quite honestly, I'm trying to get ahead of the state's case. I try to think of each phase of the trial as truly one that I want to win at each phase. And whenever I'm doing my best work, that's usually what it is that's happening. So whenever I look at the opening statement, I want to be a little bit argumentative. I want to go ahead and put things out there that are going to challenge the state's case. I want to push that envelope. And I'll talk about it in just a minute. It's so easy to overcome that objection if it's ever made. And quite honestly, most prosecutors are scared to do it scared to object to your opening statement because they don't want to view as they don't want to be viewed as though they're being obstructionist to your case. They don't want to look already even more so like they're trying to hide the ball. And you want to look at actually setting up challenges to the state's case. And I'm going to talk more about that in just a moment. I truly do believe the final point that I made on this slide, your credibility and your emotional stake in the case are every bit as important as the facts of it. I was talking to a friend about this recently. I really do believe that whenever I am emotionally invested in a case, I'm really putting myself out there in a very vulnerable way, that I'm actually showing the jurors who I am, and I'm engaged in it in a way that a lot of times lawyers just aren't. It does make a difference. That the way that you put yourself into your work, the way that you commit yourself to learning how to handle these cases, and actually sinking yourself into your client's cause and believing in your case makes a real difference in the result that you get. So I'm never one to shy away from being emotionally invested in it, because if you haven't been out in the hall after a trial's done and said, "Dear Lord, if I just win one more, I won't ask for another," you haven't really done this enough, or in a way that's really sinking yourself into it. I do it during every trial. I always say that to me. I always say like a little prayer out in the hall, like, if I can just win this one more, I won't ever ask again, and always end up asking again. But that's the way that I view that, that you should really care about it in that real way. Sorry, flipped ahead there. The theme or the theory of defense. So a lot of lawyers spend a lot of time thinking about the theme or their theory of defense. It's important, it truly is, but somewhere along the line, I think that we got hung up in the terminology too much instead of actually focusing on the purpose. Because what it really is just a guidepost for you in terms of your trial of the case. I've gone into cases before where I had a very defined theory of defense. For example, a no driving case. I went into a no driving case one time where they had a real problem proving driving. But the officer was so bad in his trial testimony about field sobrieties and about other issues that I was able to cross him and impeach him on point after point after point. The state just dismisses the case midway through trial because the officer just looked like a dummy. He wasn't paying attention. So I don't get so locked into the theory of defense that it doesn't let me deviate from other things. One thing that I do believe is very important to your opening, though, is that you are able to, for example, it's an icebreaker in the beginning of that opening statement demonstration that I just gave. The rush to conclusion is a very simple, very repeatable theory of defense that you're going to see over and over again in your DUI cases. It's one that's really easy to adapt to most of those. The prosecutor ignoring good facts and only focusing on bad facts. That's not really a clear defined theme or theory of defense, but it's one that absolutely repeats itself over and over again, and one that I use again and again in DUI cases. So don't get hung up on the terminology so much. Don't worry about, is this a theme or is this a theory, like you would in a law school trial practice class. It's not about that. At the end of the day, you're more concerned with being able to convey the ideas and the problems in the state's case than you are about, is this a theme that's well defined? Is this a theory that's well defined? And I try not to get too hung up on sort of what I consider to be sort of hokey theories or hokey themes. I'm really just there to say, I want to be the truth teller in this whole deal. I want to show you what the facts are. I want to show you what the limitations of the state's evidence are. And then you can really get to the heart of the matter, which is, can they prove this case beyond a reasonable doubt given those limitations of their evidence? That's where the problems for the state arise. And whenever I was talking about this is in fact an argument for me, that's one that a lot of lawyers have an aversion to, about the idea that they are making an argument in an opening statement. Don't be hung up on this at all. If you ever get an objection, you fix it so easily just by saying, I believe the evidence will show. And then you can actually make a point out of it to the jurors right then. If a prosecutor objects once or twice during your opening statement, just go, I believe the evidence will show. I believe the evidence will show after each point that you make. And at that point in time, one, you're scolding the prosecutor and you're teaching the jurors that, hey, I know what's going on here and I know what the rules are. I'm, again, building credibility, and I'm going to make sure that you know all the story here. So I will have absolutely no problem with the prosecutor doing that. You invite those sort of objections. They're okay. They can actually be a benefit to you and your case and the way that jurors view you and your client, whether or not they're getting a fair shake that day. Because once you get up there and you say, I want you to know what the whole story is, not just a limited set of facts to make your decision, and then a prosecutor starts objecting to that, jurors are like, hold on, not only did he or she not tell us the full facts, now they're trying to keep him from telling us the whole facts, which is a huge problem for them. Dealing with problems is obviously a big thing that we need to do during our opening statements. We need to be open, honest. We need to not overstate things. We need to actually address bad evidence in our case. And I like to do that by setting up challenges for the state. So to tell them, hey, for example, in the HGN test, horizontal gaze nystagmus test, there is no validation study produced by anyone, anywhere, that will actually correlate the clues that you observe in the horizontal gaze nystagmus test to a person's actual driving ability. Count one of the accusation charged Mr. Stapleton with driving under the influence to the extent that he was less safe. The state's going to rely upon the horizontal gaze nystagmus test in part to tell you that he was in fact a less safe driver as a result of alcohol. Whenever the officer gets up on the stand, I'm going to ask him point blank, is there any study produced by anyone, anywhere, that says that you can actually correlate the clues that you observe in the horizontal gaze nystagmus test to a person's actual driving ability? The answer to that question, I believe you're going to hear, and what the evidence is going to show, is no. There is no study that correlates HGN clues to actual driving ability. And that's what's alleged in count one. That evidence has absolutely no relevance to the issues that you decide in count one. That's the challenge that I'm setting up for them there. In addition to that, where is the video evidence of this? Why is it that it isn't something that we can actually see? Because the things that we actually see in Mr. Stapleton in this case, the walk and turn test, the one where the officer sets him up incorrectly, the one-leg stand test where the officer says he observed two clues, don't show any of those manifestations of impairment. They don't show us any indications that Mr. Stapleton was in fact impaired in his ability to drive as a result of alcohol. How does that match up with what the officer says he saw on the HGN test, the horizontal gaze nystagmus test, the eye test? How do we reconcile those two things? Well, quite honestly, they don't reconcile. They don't reconcile. There's a conflict there, and that's a reasonable doubt. Chemical tests, anytime that you have a chemical test, I know a lot of lawyers who say I try to hold back my defense. They try to hold back their defense until it's actually their case to put up their expert. I have never bought into this. I believe that you have to tell jurors what you're going to tell them. You have to tell them, and then you have to tell them what you told them. So I'm trying to create consistency throughout the trial of the case. I want to tell jurors early on what my defense is, and then I want to actually show them the defense, and then I want to repeat it to them again how it is that the state didn't rebut that defense during the trial of the case. That's what my trials typically look like. So in dealing with your chemical tests, you must get out in front of them. You obviously are dealing in jury selection with whether or not the jurors are receptive to the idea that a chemical test can be, and there can be an error in the administration of those tests, that there can be an error in the results that you get from a blood test or a breath test or urine test, whatever it is you're dealing with. But you gotta deal with that in your opening statement, I believe. I don't believe that you can hold back a defense and then suddenly spring it on them mid-trial and then believe that they're gonna be able to hold on to that, grasp it. I believe that you need to repeat those things at least 3 times to them in those different phases of the case, the opening, the evidentiary portion, and your closing. And then you're hoping that they can actually remember it, because it is very difficult for jurors to grasp what it is that's important. It needs to be short, it needs to be concise. You need to actually give it to them in very clear terms. And that's all that I'm trying to do in my opening statement. Tell them what the problem is, tell them the problem that they'll see. You're priming them to look for the problem in the evidence. And then you're going to ask them, say, hey, what's the state's response to this? Listen for how it is that they respond to it. In Mr. Stapleton's case, why does the state have this rule and then tell you that it's okay that we ignored this rule? What kind of excuse did they come up for this? Listen to it, because they're going to literally tell you that their own rule, which says that that it must be sealed, that you're not supposed to shake it, and that it must be refrigerated as soon as possible. All three of those rules that you can just ignore them. We just have them there just for giggles. It's no big deal. It doesn't matter. We can just ignore it now. And that's what they're going to tell you. So in my opening statement, I typically will acknowledge my fear of the number in a test case. In a test case, I'm referring to a breath or a blood test case. I usually will ask that they reserve judgment, but I'm doing that in voir dire as well. And in my typical breath test case, I'll have usually an observation period problem is my go-to defense in a breath test case. And I'll ask that hey, state, show us compliance with that 20-minute observation requirement. Show us how it is that you maintain the defendant in a position where you could have observed whether or not heard or observed whether or not the defendant burped or belched during that 20-minute period. And then just let them know, hey, the answer is there is going to be no compliance with that. There's going to be about a 15-minute period in this case where the defendant was in a plexiglass divider in a cage in the back of a patrol car on the way to the station. And then he's going to arrive at the station about 5 minutes before the breath test was administered. The machine was already heating up on the way to the station. And he had that test done 5 minutes after arrival there. So the 15 minutes that he's riding on the way to the station, prior to that, there is no compliance whatsoever with the observation period requirement. That's a big issue in those observation period problems in your breath test cases. And really easy to set up that challenge in your opening statement. Again, it is not overwhelming. It is not magic at all. It's just about saying, hey, there's a rule, and I want you to know that they're not going to show compliance with that rule in this case, and listen for what it is that they tell you to do with their non-compliance with that rule. Are they telling you that that rule really doesn't matter, that we just put it in there for nothing? Or are they telling you that it does matter, in which case you know for a fact from their own mouths that there's reasonable doubt in the case, and they're never going to concede that for you. And this is a sample from an opening statement that I give in mouth alcohol cases. That's references to our Georgia manuals at the bottom, but it talks about how it is that it's so important to have the 20-minute observation requirement, despite the fact that you have .02 agreement and you have the slope detector. You need all three of those requirements. I just wanted to show you a sample of how it is that I'm trying to set up that challenge for the state in my opening statement through those slides. I do believe if you haven't used slides or you're not using foam core, you really are wasting some real opportunities. Go ahead and start trying to use those visual aids in your opening statements as much as you do in your closings. They will make a huge difference. Jurors latch onto them. They know that it's real. They know that it's not just, they've heard so much talking whenever we go in there for jury selection. They have so much talking as we go through our opening statements. They want to see some stuff. They'll start loving to see the fact that you brought in things, you were really prepared to put forward your case, and you are actually building your case, your evidentiary case in your opening statement whenever you start doing that. So don't be fearful of using slides, even your openings, in a way that we do in our closings more typically now. This is another chart from a study that was done by the GBI, and I go ahead and start talking to them about failure rates in the testing for the machine. This is for a breath test for the Intoxizer 9000 that we use here in Georgia. I know a lot of people are using it throughout the nation, and this is a great study. If you're not familiar with it, I'll provide it in the materials as well. But this is an example again of something that I'm really getting into the weeds in a lot of those cases in my openings, to just go ahead and let jurors know that there are problems with this machine. In fact, the problems are so significant that it detected mouth alcohol in only 64% of the cases, which whenever they realize that this is a case about an observation period requirement, and there's a slope detector that's only 64% of the time, that's a real problem. So I can't rely upon this machine to correct for the problem. What I'm doing there is I'm already starting to knock the legs out from under the state's rebuttal to the mouth alcohol problem. And that again is just a benefit of knowing the evidence really well, understanding the science and understanding the limitations of the state's case there. This is another chart that talks about the difficulties that the machine has differentiating alcohol versus, for example, Arctic Chill ice bubble gum, piece of bubble gum, or even Public sheet cake. And this is a great chart that I use again in mouth alcohol cases where it showed us what it is. We have, in Georgia, we have a graphical representation of a person's mouth alcohol sample. So we see where it, what they thought that the mouth alcohol would look, what a normal breath sample should look like, and what they told us that mouth alcohol looked like before. For example, in Garriott's Medical Legal, we have that. And then you have a comparison of it in the actual graphical representations from the operator's manual in the Georgia Intoxicator 9000. I realize I just made a complete mess of that explanation. I'm sorry. This is a little bit unnerving here. But nonetheless, what you see is that they have exaggerated the drop-off that we expect to see as a result of mouth alcohol. And I believe there's a very clear reason. And that's because once you actually look at how it looks in Garriott's Medical Legal, it becomes much closer and much more difficult to discern which is mouth alcohol versus which not mouth alcohol. And if it looks closer, well, then your client's going to have a lot of cases in which probably the graphical representation are going to look closer to the mouth alcohol that we thought that we would see in Garriott's Medical Legal, which is a great issue for us as well. I hope that that's been helpful for you all in going through it. I'm going to stick around after this presentation to answer questions live for you. So if you have any, feel free to shoot away, and hope you guys enjoy the rest of the seminar. Thank you.